Hello and welcome to the Tuft, Lach, Jerabek O'Connell Family Law Podcast. On this episode, we'll talk about various methods of alternative dispute resolution available throughout the state of Minnesota. Hello, my name is Tom Tuft, and I'm a family law attorney and alternative dispute resolution provider at the law firm of Tuft, Lach, Jerabek O'Connell. This podcast is designed for those who may be in need of help from a family law attorney or other family law professional. We hope this will be helpful. This first episode focuses on alternative dispute resolution. I'll be joined by my law partner, Dan O'Connell, who is a highly experienced family law attorney as well as a provider of alternative dispute resolution services throughout Minnesota. This is a very general overview. If you came to this looking for information about a specific type of alternative dispute resolution, if you look down below in the narrative, you'll find instructions on where to click to get to the right spot. Otherwise, we recognize this is a fairly long video, but there is a lot to say about alternative dispute resolution. We hope you'll enjoy this, and we look forward to providing more specific episodes about each type of alternative dispute resolution. So Dan, you've been practicing law for a long time and doing dispute resolution for a long time. Just interested in hearing, your understanding of the various processes. And first of all, when someone's in dispute resolution processes, they hear the phrase ADR a lot in Minnesota. What does that mean?
Right. ADR means alternative dispute resolution. And what that really stands for is trying to get a case resolved without having to go to court and letting a judge or jury resolve the case. And there are, 6, 7, or 8 different types of alternative dispute resolution that are popular in the family law area. So I think that's what we're going to talk about today. And I would suggest we start with mediation, and in particular, what we call facilitative mediation.
Yeah, so what is that?
Okay. So facilitative mediation is a process in which a mediator is a helper, a facilitator, a person who helps the parties talk to each other and come to agreements on all the issues, hopefully, that are involved with their case, so they can get to the point where they've got everything resolved in mediation. And facilitative mediation is a process in which the mediator is more there to assist the discussions than trying to get the parties to maybe lean one way or another based on the mediator's take of how the case might get resolved by a judge if it actually went to trial. And in that type of system is called evaluative mediation. And in that process, the mediator will weigh in on the issues, we like to say, where they will tell the parties what they think, what the mediator thinks a judge will do with the issues that are going to be discussed in mediation.
Do you find you're doing more of one or the other these days?
I'm doing almost exclusively what the parties and their lawyers are calling evaluative mediation. And I think the pure facilitative mediators don't like to hear mediation called evaluative mediation, because they really don't feel that that's truly mediation, because the mediator is weighing in on the issues. But that's what most people in the divorce case realm are asking me to do as a mediator. They want me to weigh in and say what I think a judge will do.
I agree. I'm finding that, I tend to like to clarify that, but that is just what people are asking for these days. So,
and when I talk about that and ask them about that, I make sure that I tell them that just because I say this is what I think a judge is going to do, that doesn't end the story. That they can just use what I'm saying a piece of information to assist them in resolving the case, but they still own the case in terms of it's their lives, and they get to make the final decision on how they're going to try to reach an agreement to resolve the case. And I don't get to make that decision. I'm not a judge or jury, and I'm not the decision maker. They are.
Yeah, I think that's a important piece that they're getting feedback from a really experienced professional who has done probably you've done more family law than most judges, probably pretty much than any judges over the course of your career. But the fact that you're not the decider may help them be comfortable in talking through the process, talking through the issues and kind of problem solving. So I think that'd be appealing.
And when I represent a person going into mediation, that's what I want in my mediator. I want the mediator to be more evaluative. And if the mediator thinks that my idea of how the case is going to get resolved is way out of line, I want to be in front of a mediator that I trust and has a lot of experience and knowledge. And if they're telling me that they think I'm wrong about something, I'm going to listen to that and possibly readjust my position based on the input from that mediator. I'm assuming you feel the same way when you go into mediation.
Yeah, I tell my clients it's kind of like getting a second opinion. I have my view of the case and I've shared that with my client, but I only largely hear from my client. Obviously, you get the maybe the crabby letters or emails or some communication from opposing counsel, but that's often the first place that the story starts coming together in that session, and you can see the parties in action and how they view the world and sometimes you think your client's right on it, and sometimes your client hasn't told you the whole story, and it varies. So I love that setting. It's not like a deposition where you're examining the person. It's just a discussion, but you learn a lot from that.
I agree. And I like to point out as the mediator that even though I am weighing in on these issues and trying to predict what a judge may do with with these issues, even the judge doesn't know what the judge is going to do until after they've heard all of the evidence, because they're required by the rules that apply to judges to keep an open mind until they hear everything. Mm-hmm. So when we're, as a mediator, trying to predict what a judge is going to do, it's really hard to do, because judges are going to make up their own mind, and they're coming at the case with their own background, experiences, education, biases. All of those things are entering into it for the judge, and we may not be right in our prediction of what a judge may do with the issue. So ultimately, it's still going to come down to what the parties feel is a fair result, and they're the ones who get to make that decision.
Yeah, and I like the chance to put your case out there on behalf of your client when I'm sitting in that attorney chair and hearing the feedback, and sometimes it leads to creative resolutions that may not be consistent with what the mediator said, but that's still fair to everyone. It allows for deviating from the law a little bit to do what works for that family.
And I oftentimes will have cases where I don't even have to weigh in. The parties they have their discussion, and it goes in accordance with their discussion and their feelings on what should be a fair result. And I don't just jump in right away and weigh in. I let them try to get it resolved, and then when finally, if they're not getting anywhere, then that may be where I try to help them by giving them some indication of what I think a judge may do.
I find the same thing. A lot of times the parties are coming towards resolution, and my input is not welcome at that point. I mean, they'll solve their own problem as it works for their family, and sometimes they get really creative and tie things together that we wouldn't normally tie together, or they do some horse trading in ways that we wouldn't, but that it works for them and how they view things. So
Right.
I agree.
And I just basically, I encourage them to know that they can just set aside what the recommendation is and then go forward and do it however they want, resolve it the way they want to. And so sometimes I feel like they're just kind of just, in effect, kind of like waving at me or pushing me, saying, "Okay, fine, Dan, thanks for saying that, but here's what we want to do." But they don't really. I want to make sure that they feel comfortable in knowing that they don't have to follow what we're saying as a mediator.
Yeah, I completely agree. I see that a lot. So there's some other processes that have cropped up more recently that are frequently used, and so I think people are going to hear acronyms like FENE or FENE and SENE or SENE. What are those processes?
So financial early neutral evaluation, FENE, or the FENE they're talking about, is very similar to evaluative mediation. A neutral third party is hired by the parties to meet with them, hear what both sides have to say about the facts and arguments involved with issues that come up in a divorce case, and then the neutral evaluator will weigh in on the issues. I think it might be a little in that setting. I feel like I will get to the weighing in part much quicker than in the mediation process, but otherwise I think it's a lot. It's very similar. What are your thoughts on that, Tom?
Yeah, I think as they created the process, or I mean, you and I think were kind of on the among the first to do this. It started in Hennepin and then it came to Ramsey, but I think there was kind of structure to it where the people would, each tell their story, get a chance to be heard, and get that feedback, and it's really structured to do that. Whereas I agree, mediation can be a little looser. You're not hearing the story in the same way, or necessarily. There may not be the structure that mom tells her story, dad tells his story, and then you give feedback in mediation. Whereas I agree, that is more the FENE, SENE style.
Right. And then, so SENE stands for Social Early Neutral Evaluation. And that it covers issues involved with the children, such as the custody labels and the parenting time for the children, and other things that are there to protect the children, like maybe if there are chemical dependency issues, having a discussion about what types of precautions need to be put in place to make sure that the children are going to be safe in those situations. And for social early neutral evaluation, the way this also was developed in Hennepin County first, and I think what most people would consider the ideal way is to have two evaluators, a male and a female, so that you have gender neutrality in cases where there's a husband and a wife. Sometimes we have two moms or two dads, so they need to change things up in that situation. But I also like to have one of the evaluators be a parenting expert, like a psychologist or therapist, who has a lot of knowledge about children and where they're at developmentally at different ages. And then I also like to have, as one of the evaluators, a lawyer, so that the lawyer can do more of the kind of the predicting of what they think a judge may do with the facts in that case. And I feel that process is much more structured than even the FENE, because in that process, the petitioner goes first and speaks for 15, 20 minutes, in uninterrupted time and tells their side of the story, and then the respondent has the opportunity to tell their side of the story for 15 or 20 minutes, and then they each get a chance to rebut each other from what they heard the others say for maybe a few minutes to maybe 5 minutes each. And then the neutral evaluators will go in a separate room and come up with their recommendation on what they think a judge will, either from the lawyer's perspective, what a judge will do with the case in terms of custody and parenting time. And from the parenting experts' point of view, many of them are custody evaluators, and so what, from their standpoint, it's what they would put in a evaluation, a recommendation for the court. And then from that point on, the neutrals help the parties try to negotiate an agreement on all those issues that were being discussed.
So one thing that some people may ask about is, do you have if after it's done, whether it settles or not, do you have a conversation with the judge about what happened and what you think, or how does that work?
No, we don't. In all of these processes that we're talking about so far anyway, what's said in the process is confidential, and there are rules and statutes that apply to these processes that preclude the parties and the neutrals from telling the judge what was discussed. And that's designed to help the parties know that they can speak honestly, openly, they can throw out ideas, they can brainstorm and trying to reach a result without the fear that somehow what they use could be used against them. What they've said could be used against them in a court of law. So all we can say is tell the court, if the parties didn't reach an agreement, we tell the court that an agreement wasn't reached. And then if they do reach an agreement, we get the permission from the parties, or at least I do. I get the permission from the parties to tell the court if they want me to tell the court that an agreement was reached. Sometimes they just say, no, we'll take it from here, and they don't necessarily report back to the court, or they don't necessarily let me report back to the court. They just do it themselves. Is that your experience too, Tom?
Yeah, I mean, sometimes you work through a kind of a rough agreement, a bullet point agreement. So I always, tell them that's kind of one of my goals as a professional. I like to help them get their issues done, and if we can get it done that day, that's great. And it seems a lot of people, in fact, I've had court staff say they prefer the document coming from the neutral, and that the ADR ethics rules. I don't know. I think sending the document in is fine. I know those rules are being revised right now, but the court staff has said that for document security, they like the neutral to send it in so that no one has made any changes or anything to it. I don't really worry about attorneys mucking around with something like that. But yeah, so there's sometimes in some counties we use a checkbox form to say parties met, there's complete agreement, or there's partial agreement, or there's no agreement, or we're going to meet again. And that's the form, typically that goes in. But, ideally I'd love to get, an agreement in and permission to file that with the court.
And in my, all the agreements to do these processes that I have a provision that says that verbal agreements are not enforceable. In order for you to have, the parties to have a binding agreement, it has to be put in writing and signed by the parties, and if they're represented, signed by their attorneys. And I think that works really well. Everybody knows in advance what the rules are. They know that they can say, they can tentatively agree to something by saying, yeah, okay, I'll agree to that. And then they know that if they want, they can back out before they actually sign on it. In my experience, they don't back out almost all the time. But as long as everybody knows the rules are that they can back out before they sign it, I think everybody's fine proceeding on that basis.
I think that's really good to let them know up front that boundary, because I have found myself with people are getting really tentative about saying yes to something. Like, we're just trying to take one ball out of the air, so we're only juggling a dozen balls instead of 13 balls, and so you can put that ball back in play if this all doesn't come together. But I think getting ahead of it like you do is a really good idea. So there's another process called MSC. Can you tell us what that is?
Yep. That stands for Moderated Settlement Conference. And that process is designed to try to help the parties get the case settled when they're really close to the time of trial. So the other processes typically start close to the beginning of the case when not a lot of discovery has been done. And discovery is just basically exchanging information to help people learn about all the facts involved with the case. But for moderated settlement conferences, the assumption is that the parties have exchanged discovery, they're pretty much ready to go to trial, and this is their last attempt to get the case resolved before they actually have a trial. And it's typically done at the courthouse with the judge being available. Now with COVID happening, it's being done on Zoom, and it's being done with the judge being available on Zoom also. So the parties are set up typically to meet with the neutral and have their discussion, and then bring the judge in by connecting via Zoom if they want to, and it's really bring the judge in to have a discussion with the lawyers. The judge typically does not have a discussion with the parties, but they'll have a discussion with the lawyers and the neutral moderator. The lawyers and the moderator are going to try to explain to the judge what the key issues are that are preventing the case from getting settled, and see if they can get some input from the judge about how the judge sees the case without prejudging the case, but just to try to get some feel from the judge on what a judge thinks might be a fair outcome. And then the parties take that information, the lawyers and the neutral take that information back into their separate meeting with the parties without the judge present, and then go forward to try to get the case resolved. And if they do reach an agreement, either a full agreement or at least a partial agreement, whatever they've agreed to, they reconnect with the judge now via Zoom. If it was being done at the courthouse, they would go in the courtroom and they would tell the judge what the agreement is, and they would do what we call put it on the record, where they tell the judge what the agreement is in front of a court reporter is present. The court reporter takes down everything that's said. The judge asks questions to make sure the judge is satisfied that the parties understand the agreement and are entering it voluntarily. And then the judge says, okay, I'm approving your agreement. And at that point in time, they've got a binding agreement.
And yeah, I see that as kind of a last gasp process that, in fact, I've had one I did the day before trial. So, while I was shuttling into the other room, they were really doing trial prep. And one I did, the trial was starting that afternoon, and I did it in the morning. And we on both of those cases, I remember we narrowed the issues. I don't think we resolved everything, but they were that close to trial. Because one of the tools, you can use in a moderated settlement conference is the cost of a trial. Well, and most of them are, weeks or even a couple months before trial. And in those, they were ready for trial. And so, some people, I think at that point, they're like, well, we may as well spend another, day and a half and present this to the court if we're not getting what we wanted out of the moderated settlement conference process.
Yeah, and I think, I've had many cases settle on the courthouse steps, because I think sometimes people won't get reasonable until they finally realize that all of a sudden they're not going to have control of the case and a judge is going to take over control of the case. And then all of a sudden they get reasonable because they really don't want the judge to make the final decision. Of course, by then, a whole bunch of expense has been put into the case to get it ready. But as you said, I mean, in a more ideal setting, that moderated settlement conference will happen at least a month before the trial. So at least the parties have saved some of the expense of getting the case ready for trial.
Yeah, I've had that experience as well, where you're there ready to try the case, or I've even started a trial, and the judge would say something that gives everyone a hint about where the case is going, and so half day into the trial, you're out spending the lunch hour trying to button up a settlement. So that's unfortunate for the family because they've spent a ton of money by that point, but that sometimes happens.
Yeah.
So then there's some. So that's also considered a confidential process in general. You may talk to the judge, so there's a little bit of interaction. But I want to talk about. Oh, go ahead, Dan.
Yeah, so the judge can't be told what was discussed in the separate room without the judge being present. And so what does happen is what I like to do is have the lawyers tell the judge what the issue is, because as a neutral, the rules say that I'm not supposed to tell the judge unless I've got permission from the parties. What they both agree, I can tell the judge, and I just feel like, well, it's better if it's coming from the lawyers because I'm concerned that maybe I might understand that I can tell the judge something, and then somebody's going to say, well, wait a minute, I didn't want you to tell the judge that. So to just make sure that doesn't happen, I ask that the lawyers spell that out for the judge. But otherwise, what the discussions that happen are the judge isn't a part of it and isn't told what the positions are that are being taken by the parties in that separate room outside of the courtroom.
Yeah, I've had as broad a question as, Judge, how do you approach spousal maintenance? It's a 20-year marriage, and give basic facts, and the judge could say, this could likely be a permanent maintenance case or not. Sometimes they'll be a little more specific, and then depending on the difference in incomes and some of the other history, the judge may say, this kind of case in other situations, here's what I've done. They kind of give vague information, but a lot of times hearing that and even just hearing that it's not a slam dunk sometimes does help move settlement discussions along. So,
and also, a lot of the moderated settlement conferences that I've done, we have the parties have been able to reach an agreement without ever talking to the judge, up to the point where they've reached an agreement. The only time they're talking to the judge is when they're putting it on the record, telling the judge what the agreement is. And I've had some cases where the lawyers say, no, I won't agree, that we're going to go talk to the judge. They're afraid the judge is somehow going to get influenced and get some idea about how the case should be decided without hearing all the facts first. So some lawyers won't even go in there, but those same lawyers I've seen get the case settled without any input from the judge whatsoever. And I would say most of my cases that I've been the neutral on for a moderated settlement conference have been resolved without the judge's input. How about for you? Your experience too?
Yep, I completely agree. Most of the time, we do not see the judge. I've had the judge come and check in, knowing that we're there, and then before the judge goes to lunch or whatever. A lot of times we're working definitely over the lunch hour, and it seems like these often settle about 1:30 or 2 in the afternoon, right after the judge comes back from lunch, and then we're going in and putting them on the record. But yeah, I've been in that position where I thought I could get a better agreement from my client for my client than what the judge might say. So I've as the attorney been resistant to have the judge offer feedback, because, either I know how the judge ruled in a different case, just didn't want that feedback at that stage. And so I understand that position for sure.
Yeah. And by the way, just, you mentioned the judge, like maybe coming back from lunch or something like that. I've had judges stay late, after their normal quitting time, when they could have just said, no, leave and come back later. But they've stayed late to allow the parties to finish their negotiations and put the matter on the record. So, that was great of them to do that.
Yeah, I remember once in Ramsey County, the building was locked. It was after 7:00, and the judge had to escort us to let us out of the building. So, she grabbed her briefcase and purse, and we all walked out together, and she let us out through the skyway or I don't know, we had to go main floor because the building was sealed, and there wouldn't have been a way to get out. So I definitely appreciated that level of effort, and I do see that. It's not that unusual for a judge to go the extra mile to try to get help the family get things resolved.
I agree.
So then there's some other processes, and I will say I don't use them as much, but there's something called a consensual special magistrate. Can you describe what that is?
Yeah, so that consensual special magistrate is really a private judge. So the parties agree that they're going to get a neutral appointed to be their private judge in the case, and they will do what's called a stipulation and order. So they get an order from the court appointing the neutral as the consensual special magistrate, and then the consensual special magistrate meets with the parties, has a pre-trial with the parties. Sometimes we'll try to help the parties resolve the case, acting somewhat like a mediator. But if they can't get it resolved, they will have a trial with a court reporter and make decisions the same as a judge would. And their final decision, their orders, are appealable directly to the Court of Appeals, just like it would coming from a judge.
And I know you've done a bit of that work. I've been appointed, but the parties have resolved it before I've ever had to do the magistrate work. But what kind of cases are those used? Is that process used on?
I think first of all, the parties need to be able to afford to do it, because appearing in front of a judge does not cost them money other than the filing fee. So it typically is involved with people who have more money. And sometimes people want a private judge because they don't like the judge that was assigned to the case. Maybe they feel like the judge doesn't have enough experience, and they want to make sure that they have a neutral assigned to the case who has a lot of family law experience. Or maybe the timing isn't right. Like maybe the court wants to force them into getting ready for the trial in accordance with the court's own timing, and not timing that it is going to work for the parties. So that's another reason why they'll use a consensual special magistrate.
So that obviously, because you're making a decision and it could be appealed, and it's not a confidential process in any way. It's a pretty public process.
Well, I don't think, I could be wrong, but I'm pretty sure that the parties do not, in doing that process, the public can't walk in on that process like they could walk in any courtroom in Ramsey County or any other county throughout the state. So from that sense, it's private, but the results are public. The judge's orders have to be filed in that court file, that public court file that the case arose out of.
So then I'll talk about another process called special master. So how does that differ, and what what's that process about?
So being appointed a special master, that comes from the judge, and typically the judge can do it on their own volition, I believe, although I haven't ever had it that way. I've been appointed where the parties agree to have me appointed for a special purpose. Like as you know, I had a case where I was appointed to go through many, many documents and identify if those documents are protected by privileges like the attorney-client privilege or a minister privilege, a therapist privilege, that type of thing.
Mm-hmm.
And also there seems to be a trend now that, and we haven't talked about parenting consultants, but there seems to be a trend now that instead of using a parenting consultant, a court may appoint a special master to do things that are very similar to a parenting consultant, what they do, and that is make decisions involving children and custody labels and changing parenting time and making decisions involving the children, like where they go to school or if there's special needs in terms of protecting the children if a person has some kind of a chemical dependency issue and that sort of thing. So the court can appoint this person to act as a neutral and make those decisions and file those decisions with the court. And then either party can appeal that decision and go in front of the judge the judge or referee who appointed the special master and ask that the court overrule what the special master did.
I know there's different schools of thought about that, but I have seen where I was the parenting consultant, my term was up, and the judge then appointed a special master because there was not an agreement that a new PC would be appointed, and that. So I have seen it. You absolutely have seen it used in that way, and we'll talk about PC in a bit. But I've also been appointed as a PC plus, given authority over child support and other issues, and so people are creating their own processes in some ways as well.
Yep, and they have a right to do that under the rules. They can make their own process as long as they define what the process is and just follow the agreements that were reached concerning how the process is supposed to work. So, Tom, I don't do parenting consulting myself, so maybe I know you do a lot of it. So maybe you can describe that process.
So that sometimes we call it almost like a private judge in a way, but I think a better way of thinking about it, it's kind of a mediation arbitration process. So I have kind of, as a PC, I would have three roles. Coaching, so kind of talking to a parent about, how is this working for you? This is not working. Let's try this other approach. So I'll get a call from a parent in one of my cases who says, I want to go down this path. Can you help me think about how I should approach the other parent about that? And so that's one role, is kind of coaching. The other part of it, though, the main part of it is mediation, where parties are in disagreement over everything from hairstyles to tattoos to what age they can ride a motorcycle with dad. There's just all the issues, plus the traditional parenting time and holiday schedules and travel and meds and all those kind of things all can fall under the parenting consultant. So the idea is to get people together. Now we're doing it via Zoom, talk through the issues, and really in a traditional mediation sense, try to find solutions by agreement. And I find even parties that are kind of at war do come up with agreements. And I have sometimes we have the meeting almost via email even, where the discussion will start. They don't want to see each other, but they're willing to communicate via email. And so that's not ideal, but that's another way of resolving it. If they don't reach agreement, then it goes to me for decision. And so I tend to, being the lawyerly PC, tend to look at the statute and I tend to write longer decisions that kind of go through the best interest factors that, in a brief way, like a paragraph on those relevant factors. And I'll talk about, why I made the decision and lay it out there. And out of those decisions, people do have the right to take them to the judge. And, typically judges will affirm what the PC recommended. But you could have a judge say, I may not have decided that way if I was the decision maker, but I'll respect the PC's decision. Or the judge could go a different direction. I mean, the judge sees the case in a broader way, especially if they've gone to trial or had a lot of motion hearings in front of the judge. So the judge sees the full case. I just see the kid issues. And so, on one occasion, I chose a school and the judge made a different choice after they did a motion hearing. And that's kind of how the process works. I've probably made many hundreds of decisions, and maybe less than 10% have been brought to a judge. And then there's that one occasion where a judge went a different way. And again, I told the parties that's fine. That's part of the process. I didn't like being I didn't love being reversed, but that's just kind of the nature of what we do. So it's fairly intense work sometimes, and it's urgent very often. We say we don't deal in emergencies, but very often these decisions are pressing. We're heading into the holidays, and there's flight conflicts that mom says the kid should only travel during the day, and dad says, but there's a cheaper flight at night, or give me a couple extra hours with the kid if they're going to visit grandma and grandpa some distance away. So it's often rewarding, I have to say. It's challenging, but also rewarding, because very often you see people move on and are problem solving on their own. And there's always those most challenging of cases that you're making a decision. It seems like every 3 months for those hard cases, but it's never dull, for sure. I mean, on a given day, there could be an email that all of a sudden, by Friday, you've had them in either, via Zoom these days, and addressed an issue and had to either investigate more or made a decision. So it's definitely challenging, but like I said, rewarding. So.
Yeah, and I think all of these processes, I believe, are real rewarding to do. It's really, it's rewarding to be able to help people come to an agreement and avoid having to have a trial. So, that to me is very rewarding and fun.
Yeah, I've also had, I just recently had a case that I did the moderated settlement conference for. Didn't get everything done. I think we got many of the issues done, but then they still went to trial on the remaining issues, and now a couple years later they're coming back for mediation. And so I really appreciate that they trusted me enough the first time, but also are coming back a second time. That's one of the rewards of this kind of work.
That's great.
One last process I want to talk about is arbitration, and just if you can explain how that works, what that is, how that might
Sure.
occur.
Well, an arbitrator gets appointed by agreement of the parties, and in divorce cases, they often bring that agreement to the judge and have the judge appoint the arbitrator. And an arbitrator is very similar to the judge, because an arbitrator will make a decision, and it's a binding decision. And it's a decision that's much harder to get changed. When a judge makes a decision, it can be appealed to the Court of Appeals, and the Court of Appeals has a much broader scope of review for a judge's decision than for an arbitrator's decision. Arbitrators' decisions can only be overturned by the Court of Appeals for things like duress or evident partiality, things that are really the judge, the arbitrator had some kind of a bias, that type of thing. And the arbitrator doesn't have to have a lengthy order that lists a lot of findings of fact and conclusions of law like a judge will have to do by as required by the laws that cover divorce cases. And so the parties like to they like to use arbitrators because they can oftentimes get a decision quicker, and it doesn't take as long. It's not as expensive. The arbitrator does swear the parties in to give testimony. It's done a lot for personal property disputes. I think that's probably the most common divorce arbitration situation, where the parties will they lots of times will have an agreement in their divorce decree because they've resolved everything else, but they haven't divided all of their household goods and furnishings and personal property and that sort of thing. And they'll put a provision in their divorce decree that says that they will try to resolve that themselves. And if they can't get it done, like say within 60 days after the divorce decree is entered, then they will go to a neutral who will first wear a mediator hat and help them try to get it resolved. And if that doesn't work, then they'll put on an arbitrator's hat and make a decision for them. And so they basically decide who's going to get what, and don't have a real long, lengthy order that they write up in terms of their reasons for their decision and that sort of thing. But it is a binding decision. Typically, they could agree to have an arbitrator make a non-binding decision, but I never see that myself. They always want it to be a binding decision. And I always want it to be a binding decision if I'm representing a party who is going to agree to go to an arbitrator.
Yeah, I've done several personal property arbitrations, but I did one outside of that, which was concerning the house, and I had to decide the value that it was going to be listed at because they couldn't agree. So as I recall, we did it as a hearing in one of our conference rooms, and we had the parties and a court reporter, and they all, it was semi-formal compared to a lot of arbitrations are just the parties and you're talking through things, but it was it had to be because of the nature of the personalities. We had to conduct it as essentially a formal hearing, and they made their arguments and cross-examined one another, and the attorneys did, and we had at least one, but I think more, as I recall, realtors testified by phone. And so I had to set the sale price, and then I was to address as they dropped the price later on, and I would have authority over additional changes to the listing agreement, anything like that. And we only had to do that once. The property went on the market at a price, and it sold fairly quickly, and so we did not have to do the ongoing work. And that was important in that case because one party there was a non-marital claim, and the more it sold for, obviously, it helped that non-marital claim. So it mattered more to the one party than the other. The other party was paying the mortgage and wanted it sold quickly, and so there were a lot of dollars at stake if the property had stayed on the market for a long time. So that was an unusual, and it cost them several $1,000s, but it mattered enough to them to have that addressed that way.
And the parties, they can do arbitration for almost anything that's involved with a divorce. So I had one, I'm trying to remember, they had a provision about college tuition. They had money set aside for college tuition and books and other costs, and they appointed me as an arbitrator to resolve disputes, and they ended up with disputes about how the money should be spent. So I took testimony from both parties. They had lawyers present, and then I just made a decision on the issues that they presented to me. And I was also given the authority with that to award attorney's fees. So that arbitrations can cover all sorts of different kinds of disputes.
Well, Dan, I appreciate you walking us through these different approaches to ADR. I hope it was educational. I know I picked up a few things here and there. So So I look forward to, posting the podcast and sharing your knowledge with the world here. So
All right. It was my pleasure, Tom. Thank you.
I hope you got a lot out of that discussion. I always enjoy talking to Dan and always pick up a few nuggets. Even though I've been practicing 25 years, I learn a lot in talking to Dan on a regular basis. Dan, if you couldn't tell, is considered one of the real gentlemen of the law in Minnesota and a font of information and knowledge. We look forward to providing many, many of these discussions, including discussions with other members of our firm, as well as other family law professionals in the community. Thanks for watching.